Let's finish Domain 2 with three sectors that seem unrelated but share a theme. Each protects a specific vulnerability. Five focus areas. First, education. FERPA, student records, directory information, and the modern EdTech problem where children's data flows to vendors nobody vetted. Second, telemarketing and messaging. The TSR, the TCPA, the Do-Not-Call registry. And then CAN spam for email, the JFPA for faxes, and the wireless domain registry. Third, two oddly specific statutes with outsized modern importance. The VPPA, born from a Supreme Court nominee's video rentals, now a major litigation engine, and the Driver's Privacy Protection Act. Fourth, telecommunications. The Telecom Act, CPNI, the Cable Act, and FCC Privacy Authority. And fifth, the advertising ecosystem. OBA, cross-device tracking, self-regulation, web scraping, and the ethics of data collection at scale. Then we'll recap Domain 2, which is the heaviest domain on your exam. 10 slides. Let's finish this. Let's start with schools. The Family Educational Rights and Privacy Act, 1974. And here's the first thing to understand because it's structurally strange. FERPA isn't enforced with fines. It's a funding condition. If you take federal education funds, you follow FERPA. Violate it persistently, and the Department of Education can cut your funding. Has that ever happened? Essentially, no. Which tells you something about enforcement in practice. Who's covered? Educational agencies and institutions receiving federal funds. Public schools, most universities. Notably, private schools that take no federal money generally aren't covered. What's protected? Education records. Records directly related to a student and maintained by the institution or someone acting for it. Grades, transcripts, disciplinary files, class schedules. And the exclusions matter. Sole possession notes, meaning a teacher's private memory aids not shared with anyone. Law enforcement unit records. Employment records where the person isn't a student. Treatment records at post-secondary institutions. And alumni records created after graduation. Now the rights and the twist. Rights belong to parents until the student turns 18 or enrolls in post-secondary education. Then they transfer to the student. That transfer surprises parents constantly. Your child goes to university and you can no longer see their grades. The rights themselves? Inspect and review, request amendment, consent to disclosure, and file complaints. Access, correction, consent. Sound familiar? 1974. So FERPA requires consent to disclose, except when it doesn't. And the exceptions are where the action is. Directory information first. This is the category schools can disclose without consent. Name, address, phone, email, date and place of birth, participation in activities, dates of attendance, degrees, honors, and often photographs and weight and height of athletes. But here's the mechanism. Schools must give annual notice of what they treat as directory information, and parents or eligible students can opt out. Notice, opt out, not opt in. Now the other exceptions, and there are many. School officials with legitimate educational interest. And this one is doing enormous work because it covers vendors if the school designates them as school officials and maintains direct control. Other schools where the student is transferring. Financial aid purposes, accrediting organizations, judicial orders and subpoenas, health and safety emergencies, studies conducted for the institution. Do you see the school official exceptions importance? That's how EdTech works. A learning platform isn't in FERPA's text. It becomes lawful through designation. Let me give you a real example. A university adds a proctoring tool that records students' rooms via webcam. Is that a school official? They'd argue yes. Parents might argue that's a stretch. Here's my question. How much of FERPA compliance rests on a designation nobody scrutinizes? Let's stay with education because this is where the modern problem lives. Picture a school district. It has a learning management system, a maths practice app, a reading tool, a video platform, a communication app, an attendance system, a behavior tracker. 20 vendors minimum. Often far more because individual teachers adopt free tools without telling anyone. And each one collects data on children, keystrokes, time on task, wrong answers, location sometimes, behavior flags. Now, who negotiated those contracts? Often a technology coordinator with no legal training, clicking accept on terms of service written by the vendor. So, what's the risk? Data used for the vendor's own product improvement, data used for advertising, data retained forever, data breached, and school districts are heavily targeted by ransomware. FERPA's school official exception requires direct control. Does clicking a free tool's terms give you direct control? Almost certainly not. That gap is why states legislated. California's SOPIPA prohibits targeted advertising to students, profiling, and selling student data. Many states copied it. And there's the Student Privacy Pledge, an industry commitment enforceable by the FTC through Section 5. Let me tell you what I've seen. A district doing an inventory found over 1,000 tools in use. They knew about 40. Ask yourself, who's watching what happens to your children's data? Now let's talk about the phone ringing at dinner. Two overlapping regimes, and you must know which is which. The TCPA is a statute, 1991, enforced by the FCC. It restricts autodialers, artificial or pre-recorded voice calls, and unsolicited fax advertisements. It requires prior express consent for auto-dialed or pre-recorded calls to mobile numbers and prior express written consent for marketing calls. It mandates time restrictions, generally 8 in the morning to 9 at night, local time to the recipient. And here's the crucial feature. The TCPA has a private right of action with statutory damages per call. Per call. Multiply that by an automated campaign and you have a class action industry. The TSR is a rule from the Telemarketing Act enforced by the FTC. It covers deceptive telemarketing, requires specific disclosures, prohibits abandoned calls, restricts payment methods, and mandates transmission of caller ID. And the Do-Not-Call registry comes from the TSR, jointly with the FCC. Consumers register, telemarketers must scrub against it, and there are exemptions: existing business relationships, prior express written consent, charitable, political, and survey calls, which is why those still get through. Now, robocalls. Stir/Shaken is the authentication framework carriers use to combat spoofing. Here's the honest assessment. Despite all of this, does your phone still ring with spam? Enforcement against offshore actors is nearly impossible. Let's move from calls to messages. And Can Spam is a study in how weak a law can be while still being law. Can Spam, 2003, governs commercial email. What does it require? Don't use false or misleading header information. Don't use deceptive subject lines. Identify the message as an advertisement. Include a valid physical postal address. Provide a clear opt-out mechanism. Honor opt-outs within 10 business days. And monitor what others do on your behalf. Notice what it does not require. Consent. You can email anyone once without permission. It's an opt-out regime. And the name is a joke that's aged badly. Can Spam. It literally permits spam with conditions. It also preempted stricter state laws, which some argue made things worse. No private right of action for individuals. ISPs can sue. The Junk Fax Prevention Act amended the TCPA for faxes. It requires an opt-out notice on every fax and permits faxes to existing business relationships. And yes, faxes still generate litigation, mostly in healthcare. The Wireless Domain Registry is a nice detail. The FCC maintains a list of domains used for text messaging. Sending commercial messages to those addresses requires express prior authorization. So text is opt-in where email is opt-out. Why the difference? Because consumers used to pay per text. Law reflects the technology of its moment. Two statutes with wonderful origin stories. Let me tell you both. In 1987, Robert Bork was nominated to the Supreme Court. A journalist walked into his local video store and got his rental history, published it. Congress, suddenly aware their own rental records were exposed, passed the Video Privacy Protection Act with remarkable speed. The VPPA prohibits videotape service providers from knowingly disclosing personally identifiable information about a consumer's video requests without informed written consent. And it has a private right of action with statutory damages. Now here's why this 38-year-old statute matters today. Courts have applied it to streaming services and to websites with video content that embed tracking pixels. If your news site has a video player and a pixel that tells a social platform which video a logged-in user watched, plaintiffs argue that's a VPPA violation. That has become one of the most active areas of privacy litigation in America, from a video store in 1987. The DPPA 1994 came from a darker story. An actress was murdered by a stalker who obtained her address from motor vehicle records. Congress restricted disclosure of personal information from DMV records. Permissible uses include government functions, insurance, research, and licensed investigators. Notice the pattern in both. A specific harm to a specific person produced a specific law. That's the American model in miniature. Let's cover the communication sector, where the FCC rules. Start with CPNI, Customer Proprietary Network Information. That's data about the quantity, technical configuration, type, destination, location, and amount of use of telecommunications services. Essentially, who you called, when, for how long, from where. Section 222 of the Communications Act protects it. Carriers must obtain approval before using CPNI for marketing outside the existing service relationship. And the FCC has enforced this, including against carriers selling location data to aggregators, which found its way to bounty hunters. Those enforcement actions were significant. The Cable Act, Section 631, is separate and arguably stronger. Cable operators must give annual privacy notices, obtain prior consent for collecting or disclosing personally identifiable information, provide subscriber access, and destroy data no longer needed. And it has a private right of action. Now the history you should know. In 2016, the FCC adopted broadband privacy rules requiring opt-in consent for sensitive data. In 2017, Congress repealed them using the Congressional Review Act. And the CRA has a nasty feature. It bars substantially similar rules in future. So broadband privacy fell into a gap. Not FCC because of the repeal, not clearly FTC because of the common carrier exemption fights. That gap is why states started legislating broadband privacy themselves. Let's look at the machine that funds the internet. Online behavioral advertising works by observation. You browse, signals are collected, profiles are built, ads are targeted. And the money flows through an ecosystem most people cannot see. Publishers, ad exchanges, demand-side platforms, supply-side platforms, data management platforms, identity resolution vendors. Real-time bidding is the engine. When a page loads, an auction runs in milliseconds. And to run that auction, a bid request goes out containing information about you, your location, your device, inferred interests, sometimes the page you're on. Think about that. Your data is broadcast to dozens of potential bidders, most of whom don't win and who now have it anyway. Cross-device tracking is the next layer. Deterministic matching uses a login so they know it's you. Probabilistic matching infers it. Same IP address, similar patterns, overlapping behavior. Self-regulation is the industry's answer. The DAA's Ad Choices program, that little blue triangle, the NAI's code, both offer opt-out mechanisms. But here's the honest problem. The opt-outs are cookie-based. Clear your cookies, you clear your opt-out. Your preference not to be tracked is stored in the very technology you're opting out of. Do you see the absurdity? That's exactly why global privacy control emerged. We'll get there in the state chapters. Let's close the sector tour with something genuinely unsettled: scraping. Here's the question: is it legal to collect publicly available data at scale? The instinct says yes, it's public, anyone can look at it. But scale changes things. One person reading one profile is different from a machine copying 200 million. The Computer Fraud and Abuse Act was the main weapon. It criminalizes accessing a computer without authorization. But in the high-Q litigation against LinkedIn, and later reinforced by the Supreme Court's Van Buren decision narrowing the CFAA, courts move toward a gates-up or down approach. If data is public, no authorization is required. So scraping it isn't unauthorized access. So scrapers won that round, but not the war. Because breach of contract survives. Terms of service prohibiting scraping are enforceable. Copyright can apply to some content. Trespass to chattels if you overload servers. And then AI arrived and made this urgent. Training data. Models built on scraped content. Litigation everywhere. Here's the ethical question I want to leave with you, because the law hasn't answered it. Someone posted something publicly in 2010. Did they consent to it training a model in 2026? Did they consent to it being combined with 1,000 other sources to build a profile of them? Publicly available and freely usable are not the same thing. The law is still catching up to that sentence. Let's consolidate. Domain 2 is the biggest sectoral block on your exam, and there's a lot to hold. Start with the organizing principle. Every sectoral law exists because of a specific failure. HIPAA, digitizing health records; GLBA, mega mergers; FCRA, secret credit files; VPPA, one video store; FERPA, student records. If you remember the failure, you'll remember the scope. Second, scope is always the first question. Who's covered? HIPAA covers entities, not data. GLBA covers financial institutions broadly defined. COPA covers under 13. FERPA covers federally funded schools. Get scope wrong and everything after is wrong. Third, know the consent defaults. GLBA is opt-out for sharing. CAN spam is opt-out. TCPA is opt-in for auto-dialed marketing. Text messaging is opt-in. COPPA is verifiable parental consent. NAIC number 672 is opt-in for health data. Fourth, private rights of action. This is where litigation lives. TCPA has one, VPPA has one, Cable Act has one, FCRA has one, HIPAA does not, GLBA does not. That last list is worth memorizing cold, because when a question asks who can sue, that's what's being tested. Fifth, watch the old statutes doing new work. VPPA and pixels, FCRA and background screening. Take a breath, government access is next.